Modern real estate practice. Page 39, continued. Fair housing practices. For fair housing and other civil rights laws to accomplish their goal of prohibiting discrimination, real estate professionals must apply them routinely. Compliance also means that real estate professionals avoid violating not only the law, but also the ethical standards of the profession. The following discussion examines legal and ethical issues that continue to confront real estate professionals. Page 40. Blockbusting. Blockbusting is the act of encouraging people to sell or rent their homes by claiming that the entry of a protected class of people into the neighborhood will have some sort of negative impact on property values. Blockbusting was a common practice during the 1950s and 1960s when unscrupulous real estate professionals profited by fueling white flight from cities to suburbs. Any message from a real estate professional, however subtle, that property should be sold or rented because the neighborhood is undergoing changes, is considered blockbusting. It is illegal to assert that the presence of certain persons will cause property values to decline, crime or antisocial behavior to increase, or the quality of schools to suffer. The critical element in blockbusting, according to HUD, is the profit motive. A property owner may be intimidated into selling a property at a depressed price to the blockbuster, who in turn sells the property to another at a higher price. Another term for this activity is panic selling. To avoid accusations of blockbusting, real estate professionals should use good judgment when choosing locations and methods for marketing their services and soliciting listings. Steering. Steering is the channeling of home seekers to particular neighborhoods or discouraging potential buyers from considering some areas. In the rental process, steering occurs when the landlord puts members of a protected class on a certain floor or building. Another form of steering occurs when the landlord tells a prospective tenant that no vacancy exists when in fact there is vacancy. When the misstatement is made on the basis of a protected class, the prospect is steered away from that building. In any case, it is an illegal limitation of a purchaser's or renter's options. Advertising. Advertisements of property for sale or rent may not include language indicating a preference or limitation. No exception to this rule exists, regardless of how subtle the choice of words. HUD's regulations include the types of language that are considered discriminatory. One such regulation can be found at www.hud.gov/offices/FHEO/library/part 109 PDF. Figure 3.2 shows some examples of language that is permitted and language that is considered discriminatory and not permitted. An advertisement that is gender specific, such as a female roommate sought, is allowed as long as the advertiser seeks to share living quarters with someone of the same gender. The media used for promoting property or real estate services cannot target one population to the exclusion of others. The selective use of media, whether by language or geography, may have discriminatory impact. For instance, advertising property only in a Korean language newspaper tends to discriminate against non-Koreans. Similarly, limiting advertising to a cable television channel available only to white suburbanites may be construed as a discriminatory act. If an advertisement appears in general circulation media as well, however, it may be legal.